Welcome to this video on sentencing and appeals. We'll be starting with sentencing first, but just before we do, I would like to acknowledge the traditional owners of the land on which we live, work and learn, and pay my respects to their elders past, present and emerging. The purpose of this lecture is to introduce you to some principles of criminal punishment. Note that sentencing the accused is an act of state, in that it is an exercise of judicial power and the judiciary is an arm of government. In contrast with what you may have seen in the movies, which usually reflects the criminal justice system in America, juries play no part in the sentencing process. However, the jury is able to make a recommendation of leniency, but the court is not required to take that into consideration in the sentencing process. In Queensland, the primary legislation is the Penalties and Sentencing Act 1992. For Commonwealth offences, the relevant legislation is the Crimes Act 1914. The sentencing of children is generally governed by the Youth Justice Act 1992 in Queensland. We will be focusing on the Penalties and Sentencing Act 1992 because that gives us the opportunity to explore all of the broad principles and considerations in the sentencing process. Note that except where legislation provides for a mandatory or minimum penalty, sentencing is a matter of judicial discretion in relation to both the type of sentence and the length of any sentence. It should be noted, though, that this does not mean that the judge can just impose any random sentence they would like without reference to similar cases or matters specified in the Penalties and Sentencing Act. The legislation and similar cases guide the judge's exercise of discretion. Under the Penalties and Sentencing Act, either party may make a submission as to the sentence or the sentencing range. It's common practice for both parties to make submissions with example cases to indicate the sentencing range for the offence. In Queensland, heavy reliance is placed on precedents in sentencing where the offence is indictable. Both parties will regularly refer to sentences previously imposed to assist the court in finding the sentencing range and discuss the similar and differentiating features. The court often outlines the similarities and differences with those cases when explaining its reasons for imposing the particular sentence. One of the primary purposes of the Penalties and Sentencing Act 1992 is to ensure consistency in the approach towards sentencing offenders, and this is expressly stated to be a purpose of the legislation in Section 3, subsection D. These sentencing guidelines are contained in Section 9 of the Act, so make sure you spend some time familiarising yourself with the content. Note that Section 9, subsection 1 states that that particular subsection contains the only purposes for which a sentence may be imposed on an offender. You will see that this then leads into a list of the purposes for which a sentence may be imposed, and they are set out in paragraphs A to F. This includes, under A, to any extent or in a way that is just in all the circumstances. This sentence reflects the principle of just punishment. This is sometimes called just deserts, and it is also known as the principle of retribution, which means that the punishment must be proportionate to the crime and the defendant's level of blameworthiness. Note, however, that it does not mean an eye for an eye, which is often how lay people understand the word retribution. Consistency in sentencing is inherent within considerations as to what is proportionate. It is important to consider how the court has sentenced similar cases before. This involves looking at previous cases to determine the sentencing range. In Wong, which is actually a New South Wales case, the offender was sentenced to 12 years imprisonment for importing a range of narcotics, including a large quantity of heroin. The sentence was increased to 14 years on appeal to the Court of Appeal of New South Wales. The court also issued a guideline judgment. Now, these types of judgments in other jurisdictions provide guidance on the sentencing range for an offence of that type. In this particular case, the Court of Appeal identified quantities to assist with determining the level of offending. So, for example, trafficking up to 200 grams is regarded as low-level trafficking with a sentence range of up to so many years, and then mid-level trafficking is 7 to 9 years, and so on. The question on appeal to the High Court was whether the guidelines were unlawful when considered against common law sentencing principles and also statutory ones. The joint judgment, with Justice Kirby giving a separate judgment but agreeing with the joint judgment on this point, said that numerical guidelines such as those provided in this case either take account of only some of the relevant considerations or they fail to address considerations of proportionality. It was noted that discretionary decision-making can never be uniform, but it should be systematically fair, and that involves reasonable consistency, amongst other things. Chief Justice Gleeson noted at paragraph 6 that all discretionary decision-making carries with it the probability of some degree of inconsistency, but then went on to say that the outcome of discretionary decision-making can never be uniform, but it ought to depend as little as possible upon the identity of the judge who happens to hear the case. Like cases should be treated in a like manner. The administration of criminal justice works as a system, not merely as a multiplicity of unconnected single instances. It should be systematically fair, and that involves, amongst other things, reasonable consistency. So we can see from that quote that there is an emphasis on the fact that there should be consistency in the approach, but it must also take into account the specific circumstances of the case as well. An aspect of the principle of consistency is the idea of parity, in that co-offenders should be treated alike. In Crown against Nagy, the court noted that significant disparity between co-defendants may generate a justifiable sense of grievance. Moving back to section 9, subsection 1, paragraph B, another purpose for which sentence may be imposed under B is to provide conditions that the court considers will help the offender be rehabilitated. This paragraph therefore reflects the principle of rehabilitation of offenders so that they can reintegrate and become active law-abiding members of the community in the future. This is often the focus with young offenders, the idea being to try and rehabilitate them before they become career criminals. At paragraph C of section 9 subsection 1, another purpose is to deter the offender or others from committing the same or similar offence. This paragraph contains reference to both individual and general deterrence. Individual deterrence, which may also be called specific deterrence, is aimed at deterring the particular individual before the court from committing further crimes in the future. General deterrence is aimed at deterring others from committing the same or similar offences. So general deterrence sends a message to the public, whereas specific deterrence focuses on the message to the defendant. Deterrence is commonly raised as the solution to increasing crime rates. Often, the press will call for harsher punishments for those who commit certain offences, stating or implying that people will be deterred from committing those offences as a result of the harsher penalty, which is clearly relying on the principle of general deterrence. However, research shows that offenders aren't necessarily deterred by sentence. Some commit crimes on impulse, in which case deterrence has no effect on their thought processes at all. An example is capital punishment in the United States for murder. This does not deter individuals from committing murder, and we know this because murder rates remain high in those states that have the death penalty. For those who are planning to commit an offence, they may perceive that detection rates are so low that it is unlikely that they will get caught, and again that general deterrence is not effective. For others, desperation may cause their offending. So in practice, you may see clients regularly prosecuted for theft. In some cases, the court would increase the punishment on each consecutive occasion in an attempt to deter them from offending, but this did not look at the root cause of the stealing. For example, if all the items stolen are food items, they're probably being used to feed the individual's family. Once convicted of stealing, then that individual is stuck in a vicious cycle because they can't obtain employment with a dishonesty offence like stealing on their record. So in that situation, poverty has caused the stealing, and no amount of deterrence would be effective in such cases until that person is no longer on the poverty line. In addition, you may also see in practice cases where desperate offenders commit a crime in the hope that they'll receive a custodial sentence so that they will have shelter, a bed and food. So deterrence is not the magic bullet that is sometimes set out there in the media. Going back to section 9 subsection 1 paragraph D, another purpose is to make it clear the community denounces that sort of conduct. So this reflects the principle of denunciation, telling the defendant and the community that this sort of conduct is unacceptable. Denunciation is relevant in relation to specific types of offences. So, for example, where the offence involves undermining confidence in the legal system, such as the case of Fingleton. Magistrate Fingleton was charged with threatening detriment to a witness in retaliation for that witness having given lawful evidence in a judicial proceeding. In essence, a magistrate was challenging a decision by Chief Magistrate Fingleton to transfer the magistrate to a regional area. One of the other magistrates was going to provide an affidavit in support of their colleague. Chief Magistrate Fingleton then threatened to demote that colleague for being prepared to give evidence in support of the magistrate who was being relocated. The Court of Appeal noted the seriousness of the allegation. Witnesses need to feel confident that they will not be victimised for giving evidence, and the ends of justice will be defeated where they feel that they are not able to do so. In this case, the offending was more profound because it was committed by a judicial officer whose duty it is to uphold the law and to protect against the kind of conduct of which she was found guilty. So there's clearly a reference to denunciation in those reasons there. Now note that the conviction was later overturned by the High Court on other grounds, but the point about denunciation in relation to judicial officers and their role in the administration of justice are still relevant. Another example is the case of Pangello. Pangello was a solicitor who was charged with conspiring to pervert the course of justice by bribing a public officer, which in this case was a police officer. The accused told the police prosecutor that he would make it worth his while if he decided not to proceed with charges against his client. The court noted that there was a difference between a client attempting to bribe a public official and where a lawyer attempts to do so. Given the role of lawyers in the justice system and their ethical and professional responsibilities, the court highlighted that the conduct strikes at the very heart of the justice system and must be severely punished. The police are in constant contact with members of the legal profession, and the opportunities for bribery are significant, so the court's sentence was designed to denounce this type of conduct on the part of lawyers. Going back to Section 9, subsection 1, paragraph E, another purpose is to protect the community from the offender. This reflects the idea that the public needs protection from certain defendants who are particularly violent, commit sexual offences, or have a tendency to commit crimes on a large scale. And finally, paragraph F states that a combination of two or more of the matters listed in A to E may also be a basis for sentencing an offender. So, in essence, the purposes can overlap at the same time. Moving on to considerations to which the court must have regard, subsection 2 contains a list of matters to which the court must have regard when sentencing the defendant. Note the word must means that this is obligatory. Make sure you spend some time looking at section 9, subsection 2 as well. You'll see that this list is very long, with matters listed from A through to R. It is very important that you familiarise yourself with them. Try and match each item in the list to one of the principles of sentencing we discussed in relation to section 9, subsection 1. So, for example, going back to the principle of retribution or just deserts listed in section 9, subsection 1, paragraph A, we can see this principle is clearly reflected in section 9, subsection 2, paragraph C, which requires the court to consider the nature of the offending, how serious it was, the harm to the victim, and the effect of the offence on children exposed to or who witnessed the event. Paragraph D states that the court must have regard to the blameworthiness of the offender, and E refers to the injury, damage, or loss caused to the victim. So these factors require the court to consider the gravity of the offence and is looking for proportionality to the offence and its effects. In Veen and the Queen No. 2, Veen was sentenced to life imprisonment for manslaughter. Now remember that life imprisonment is not mandatory for manslaughter, only murder. Veen was a prostitute, and while intoxicated he stabbed a man repeatedly with a bread knife. He was charged with murder but was convicted of manslaughter on the basis of diminished responsibility. Veen had been previously convicted for a similar offence. In that original offence, he had stabbed a client over 50 times with a knife and was convicted of manslaughter again on the basis of diminished responsibility due to the fact that he was suffering from brain damage. On sentencing for the first offence, the judge commented that life imprisonment was necessary to protect the community. The High Court overturned that decision on appeal and emphasised that the sentence could not be increased beyond what was proportionate purely on the basis of protecting the community. The High Court reduced the sentence to 12 years imprisonment. However, in the second case, So Veen number 2, Veen again appealed against the sentence on the basis that the life imprisonment for manslaughter was manifestly excessive. The High Court noted that the maximum penalty prescribed for an offence is intended for cases falling within the worst category of cases for which that penalty is prescribed. The majority noted that this does not mean that a lesser penalty must be imposed if it's possible for the judge to think of an even worse case, but a sentence which imposes the maximum penalty offends the principle if the case is recognisably outside the worst category of cases. So, in relation to sentencing the accused, with reference to his previous conviction for manslaughter in similar circumstances, the court noted that it cannot be given such weight as to lead to the imposition of a penalty which is disproportionate to the gravity of the instant offence. However, the High Court dismissed the appeal because it determined that in this instance the life sentence was proportionate to the gravity of the offence. One of the differences between the first and second offence was that there was provocation in the first case, but an absence of provocation in the second, as well as the fact that Veen was older and had a previous similar offence. These factors were relevant in the assessment as to whether the sentence was proportionate. In this case, the majority also noted that imprisonment is a sentence of last resort, recognising the disastrous consequences of imprisonment on an offender. This is also reflected in the legislation in Section 9, subsection 2, paragraph A, which states that the court must have regard to this and that a sentence that allows the offender to stay in the community is preferable. Although note that the Act goes on to state that this particular principle does not apply in certain circumstances, such as where the offence is one of violence or resulted in injury to the victim under Section 9, subsection 2, capital A, or where the offence is of a sexual nature committed in relation to a child under 16 years of age under Section 9, subsection 4, paragraph B. Under Section 9, subsection 2, paragraph F to paragraph GB, the court must also have regard to the background and prospects of the offender, such as the offender's character, age, and intellectual capacity, any hardship the offender or their family might suffer, and whether the offender was a participant in a criminal organisation at the time of the commission of the offence. Family hardship resulting from imprisonment may therefore be a mitigating factor. For example, in Crown against Costi, the offender was the primary carer of young children, and this was taken into account in determining sentence. Looking at the offender's antecedents is also part of the sentencing process. Under Section 9, subsection 10, each previous conviction must be treated as an aggravating factor if this is reasonable, having regard to the nature of the previous conviction, its relevance to the current offence, and the time that has elapsed since that previous conviction. Section 11 expands on the reference to the offender's character and states that the court may consider the number, seriousness, date, relevance, and nature of any previous convictions, the history of domestic violence orders made or issued against the offender, any significant contributions made to the community by the offender, and any other matters the court considers relevant. In Veen, the majority noted that the antecedent criminal history of an offender is a factor which may be taken into account when determining the sentence to be imposed, but it cannot be given such weight as to lead to the imposition of a penalty which would be disproportionate to the gravity of the instant offence. The quote goes on to say that to do so would impose a fresh penalty for past offences. The antecedent criminal history is relevant, however, to show whether the instant offence is an uncharacteristic aberration or whether the offender has manifested in his commission of the instant offence a continuing attitude of disobedience of the law. In relation to the offender's contributions to the community and other relevant matters, in Ryan and the Queen, the High Court noted that there is a two-step approach in relation to the good character of the accused. First, it must be determined whether the offender is of otherwise good character. At this stage, the judge will not consider the sentence for which the offender is being sentenced and is looking at prior conduct. The second step is that the court must look at the weight to be given to the previous good character of the accused, and this will of course vary according to the circumstances. Note that generally intoxication is not regarded as a mitigating factor, and this is for policy reasons, but addiction may be relevant. In Crown against Hammond, the Queensland Court of Appeal noted, "In our view, it is a factor that may help an offender to the extent of showing that his or her descent into the crime in question was a secondary consequence of desperation produced by human weakness rather than a primary choice. It is, however, a two-edged factor. It may also tell the court that rehabilitation is going to be difficult." Note that the interests of the criminal justice system are also relevant under Section 9, subsection 2, paragraphs H and I, which include reference to the prevalence of the offence and any assistance that the offender has given to the investigation of that offence or other offences. Cooperation with law enforcement agencies may also be taken into consideration under Section 13, capital A. In Postiglione and the Queen, giving evidence to the prosecution and testifying against conspirators was regarded as assistance to law enforcement. The court recognises that it can help in the apprehension and conviction of other offenders, but may also result in endangering the offender. Note when sentencing, the totality must be considered. So, for example, the court should have regard to time spent in custody before sentence, whether a sentence is imposed on an offender in other jurisdictions for offences committed around the same time, also whether a sentence is already imposed on the offender but that's not yet been served, as well as a sentence that the offender is now liable to serve because of the revocation of previous orders. So, for example, revocation of an order suspending imprisonment for a previous offence or revocation of a parole order will mean that the offender is already going to serve some time, and that must be taken into account during the sentencing process for the current offence. So those provisions that I've just mentioned there are set out in sections 9, subsection 2, paragraphs J to M. Other relevant factors set out in section 9, subsection 2 include, for example, the offender's compliance with a previous community-based order, the completion of any rehabilitation or other intervention programs, representations by a representative of the community justice group in the offender's community if the offender is an Aboriginal or Torres Strait Islander, and if the offender is Aboriginal or Torres Strait Islander, it may also include cultural considerations and considerations of disadvantage or intergenerational trauma. And finally, there is also a catch-all of any other relevant circumstance under paragraph R. When considering aggravating and mitigating factors in sentencing, keep in mind the difference between circumstances of aggravation, which must be specifically proven as an element of the offence, such as assault occasioning bodily harm in company, and aggravating factors that are considerations relevant to the sentencing process, such as the fact that the offender committed the offence while on bail for another offence. That's not an element of the offence itself, but it tends to push the sentence to the higher end of the range. Note that certain types of offences have further considerations. So, for example, in relation to violent offenders or offences that result in physical harm to the victim, Section 9, subsection 3 prescribes a number of factors that the court should primarily consider when sentencing. Under Section 9, subsection 3, paragraphs A to K, such factors include the risk of physical harm to members of the community if a custodial sentence is not imposed, and the need to protect the community against that risk. Also, any disregard for public safety at the time of the offence. And in relation to the gravity of the offence, Section 9, subsection 3, paragraphs C to F place further emphasis on the personal circumstances of the victim in this violent offence context. So the circumstances of death, injury or damage, the nature or extent of the violence used or intended to be used. And under Section 9, subsection 3, paragraphs G to J, the offender's criminal history, age and character, any remorse or lack of remorse, and any medical, psychiatric, prison or other reports are also primary considerations. For offences of a sexual nature committed in relation to a child under 16, Section 9, subsection 4, paragraph C provides that an offender must serve an actual term of imprisonment unless there are exceptional circumstances. Under subsection 5, in deciding whether there are exceptional circumstances, the court may have regard to the closeness of age between the offender and the child, and section 9.6 contains numerous factors which the court should have regard to when sentencing. Regarding the offender's guilty plea, which saves the court time and costs and also prevents witnesses having to provide evidence at trial, Section 13 of the Act states that the court must take into account a guilty plea and it may reduce the sentence. In addition, the court must have regard to the time the guilty plea was entered or indicated to the relevant law enforcement agency under subsection 2. Note that the later the plea, the less likely that the reduction will be significant. In fact, a reduction could be denied altogether where there is a very late plea. Under Section 13, subsection 3, the court must state in open court that it took the guilty plea into account when determining sentence, and if no reduction is made, it must state this in its reasons in open court under Section 13, subsection 4, paragraph B. Although the court is not required to specify the amount of the reduction, this is common practice as it assists the Court of Appeal if it is reviewing sentences on appeal. The reduction in head sentence for a guilty plea is usually somewhere between 10 to 30% depending on the timing of the plea. In Queensland, early parole may be an option rather than a reduction in the head sentence. So under section 160B, subsection 3 of the Act, where the sentence is for 3 years or less, the court must fix a date for parole. This date can obviously take into account the guilty plea. In other cases, which are obviously beyond 3 years imprisonment, the court may fix a date for eligibility for parole under sections 160C and 160D. Note though that in that case they're just setting the parole date, at which point the parole board can consider whether to release the offender but may not do so. A broad range of sentencing options are available to the court, and these are set out in the Act from Part 3 onwards. I'll just provide some common examples here to give you a general idea, but this is something that you will need to become familiar with if you intend to practice criminal law. In section 19, subsection 1, paragraph A, the offender may be released absolutely, or under paragraph B, on recognizance, with or without sureties, on the condition that the offender be of good behaviour. Conditions may also be imposed in relation to drugs and alcohol, such as a drug and alcohol referral course. The offender may be required to make restitution and pay compensation under Division 4. The court may also make non-contact orders under Part 3A or banning orders under Part 3B. Fines are set out in Part 4. The offender may be sentenced to probation under Part 5, Division 1, and the court may make a community service order under Division 2 of Part 5. Note that a sentence may be suspended under Part 8. Section 144, subsection 1 of the Act states that the court may suspend a sentence if the court sentences the offender to a term of imprisonment of 5 years or less. Note that the sentence may be suspended in whole or part. Part 9 of the Act concerns terms of imprisonment, and indefinite sentences are dealt with under Part 10. Under Section 12 of the Act, the court may determine that it will not formally record a conviction against the offender. This doesn't affect the fact that the accused was found guilty, though. It just means that it does not form part of the accused's conviction history. Section 12 states that the court must have regard to all the circumstances of the case, including the nature of the offence, the offender's character and age, and the impact that recording a conviction will have on the offender's economic or social well-being or chances of finding employment. However, in some instances, such orders will not be possible due to the nature of any accompanying sentence, such as a suspended sentence where it is mandatory to record a conviction. Where the offender is facing a number of separate charges and the cumulative effect of each of those sentenced separately would result in a substantial sentence that would be disproportionate to the level of criminality involved, the court should impose a sentence that reflects the totality of the offences and identify an appropriate aggregate sentence rather than sentencing each offence individually as cumulative sentences, and this comes from the case of Crown against Nagy. Note that not only can concurrency be applied to an event in which there were several offences committed at the same time, so such as where there's a fight and the accused attacks several people, so there are several assaults against several individuals. It can also apply in the context of a spate of criminal offending over a short period of time. So, for example, where the accused has engaged in many burglary offences over the course of a week or a month. In relation to a term of imprisonment, under sections 155 and 156 of the Act, subject to some exceptions, there is a preference for sentences to run concurrently unless otherwise ordered.